Good morning, Advocate Hassim.
Good morning, Deputy Chief Justice.
How are you this morning?
I'm very well, thank you. And you?
I'm good, thanks. Are you ready to run?
I'd like to think so.
Okay. Don't worry, you're in a safe zone.
Thank you.
We'll take good care of you. You were born in the KZN.
Yes, I was. It's a funny story. But I left there when I was 3 months old, so I'm not sure that I'm really from Natal, but that's where I was born.
But, okay. You hold 2 degrees, a Bachelor of Arts and an LLB from Wits.
That's correct.
Okay. You started out as an attorney.
Yes, I did. I think I did my articles in 1991, and those years we had to do 2 years of articles, which was a wonderful thing. I benefited from that, yes. So it was for 2 years of an articles, and then I practiced for just a little under a year, I believe.
All right. And then you decided to go to the bar?
Yes, I did.
All right. Where? In Pretoria?
Well, that's also a story. I'm from Pretoria. I did my university, I attended university in Johannesburg. I did articles in Pretoria. I did pupillage in Johannesburg, and I came back to Pretoria to practice.
All right.
So I did pupillage at the Johannesburg bar, yes, and returned to Pretoria shortly after the completion of pupillage.
Okay. And you're still in Pretoria?
I still live in Pretoria, yes.
How long have you practiced as an advocate?
29 years.
And I see from your papers that you've had a varied practice.
I have. I've been fortunate, Deputy Chief Justice.
And you have appeared in pretty much all the courts of this land.
Yes, I have.
Do you have any area of specialty, or is your practice general?
I have a general practice. I have an interest in certain areas, but it's a varied practice. There's some things that I don't do, but other than that, I'd like to consider myself as a general practitioner.
And by all indications, your practice has been quite successful, and we all know just how tough it is for women in our professions.
Yes, it is.
What has been the secret of your success?
That's a difficult question, but my assessment has been, I joined the Pretoria Bar just after the elections. I started off, I finished pupillage in June of 1994. I then came to the Pretoria Bar, and I believe that there was a lot of focus on Pretoria because of its history as being a conservative city. And I believe that that move to try and instruct people of color was very beneficial to me, and that's where I started getting work. I was also fortunate when I did my articles, I built up relationships. And those relationships took me through. Visibility is very important, of course, when you start off at the bar, and that gave me visibility. And then it was good luck, and it was the support of wonderful people. There were attorneys' firms, mainly small firms of attorneys that supported me, but it gave me visibility, and I think there was a little bit of luck there as well.
Yeah. Well.
But one of the things was there was a senior counsel on our floor. I can mention him. It was the former Deputy Chief Justice. And he would encourage, he would walk past my chambers. I'd see him walking past my chambers at 9 o'clock at night, and there'd be that stop at my door and encourage me. And that was, I can say to you that was enormous comfort. So it was a little bit of everything. I'd like to think that there's lots of people that contributed to that.
Well, yeah, it always takes a village to raise a child.
Yes.
You do many things, and among those, you've been a small claims court commissioner and an arbitrator.
Yes, I've been doing some arbitrations. More recently, I've been doing more arbitrations than I had been before.
And why is that, if I may ask?
I beg your pardon?
Why is that, if I may ask? How did that come about? Or you just getting more work?
No, I think what happens is when one becomes more senior, you find that your practice takes a turn that you don't really expect. And I think that there's also there's a move to giving women more work. The arbitration, that area of practice has been reserved for more senior silks, and I was asked whether I was not interested in joining, becoming a member of AFSA. And I found that once I did that, there were people that requested me to act as an arbitrator. So it's been recent.
All right. And among the many things you do still is you chair the Training and Development Committee of SAULA.
Yes, I do.
Precisely what happens there?
What we do is, it's been a little bit difficult with COVID, but in some way there have been some benefits. So we have training sessions, virtual sessions. For the past 2 years, I think it was 2022, we did the training on a very high level, very specialist areas. And this year, I decided that there was a need to start off with what I called the ABCs of practice management, the ABCs of writing. So we have sessions, and we've now introduced them. We were trying to have weekly sessions. The last month or so, that hasn't been possible. So it's various topics we choose. We choose topics that we believe will be beneficial to young practitioners and more senior practitioners alike.
Okay.
It also gives an opportunity for, largely women attend those sessions. We've not excluded men from those sessions, but it also gives them an opportunity to network, and it's also a form of, it's also a support structure for especially the young women that attend those sessions.
Right. I was deeply touched and highly impressed by the deluge of letters of support, especially from young women in the profession who have written in, explaining just how much help you've been to them in their struggle as they make their way, they navigate their way in this field.
I was surprised when I read those, and I was touched too. I'm very pleased I've made a little bit of difference in their lives.
Yeah, that is making impact. One of the things that is mentioned is the WhatsApp groups that at first blush one may say, it's just one of those groups. But when you look deeper, it appears that a lot of profound work is done there. What gave you an idea to start that?
Deputy Chief Justice, it's been a long time where I thought about putting in place a structure which will allow women to network, for women to get support. It's not, when you sit in when you're a single practitioner, you sit in a small law firm, you find yourself confronted, as I have been at the bar, with the simplest of questions that either you can't grasp because it's presented as being very complex, or they're new issues that you don't know how to deal with. And it's always useful if you can knock on somebody's door. But of course, we can't do that. And I inadvertently created a group the one day. I think it was around about Christmas time, and I wanted to send messages to friends. And I inadvertently created a group. And people got feverishly, I got messages about what is this group, and I then realized I could create a WhatsApp group. That was one of my smarter moments. And then created the group. It was a handful. It started off with friends. And to my surprise, it's grown. And the women, there's only women on the group, I'm afraid. We support each other. And at any time of night or day, if you pose a question on the group, you will find somebody that comes back with the answer. But not only that, it gives us all an opportunity to debate issues. And I find that to be extremely refreshing. I've learned so much on that group. So it's been as beneficial to me as it has been to the younger practitioners.
And you have well over 160 members in that group.
Yes, it might be more, it might be less. There was a time when WhatsApp had a limit on the number of participants. I think it was 256. And at that stage, we couldn't get any more, we couldn't allow any more participants. But with these things, people come and people go, and it could be about 160, yes.
You have acted in the High Court.
Yes, I have.
Okay. I'm not going to ask you any in-depth questions on that aspect. I'll leave it to Judge President Mlambo, who's very meticulous when it comes to these things. All I want to know is how long that your stints have been, and how many judgments you've been able to produce, if any, and if any of them have been reported.
Deputy Chief Justice, I last night counted how many weeks there would be. I haven't looked at what is on the schedule I've now been given, but my estimate was, and it sounds, the JP Mlambo will correct me, but I think it could be in excess of about 45 weeks. I initially started off, I was approached by Judge President Shabalala in Natal, in the KZN to act, and I remember doing 4 and 3, 7, about 10 weeks there. So the list that I initially was given indicated 34 weeks. To that must be added the 10 more, and I do believe that there was a term, so I would add 6 weeks. So it was an extended, over the years I've accumulated a number of weeks. I would think it was, I don't believe it was anything less than 40 weeks. But the Judge President Mlambo will probably correct me.
Yes. And any written judgments?
Yes. I've prepared 55 written judgments. 55 of those, 3 have been reported. The one I marked reportable, which was, it dealt with the institution of legal proceedings against certain organs of state. And the second judgment that I wrote that was reported, what marked unreportable, was a judgment which dealt with Section 13, that had to deal with security for costs by a company after the New Companies Act came into force. And you might recall that Section 13 in the 1973 Act was done away with, and there wasn't a similar provision in the new Act. So that was reported, and recently I've had another case reported. Mm-hmm. So all in all, there's been 3.
All right. You do not have any reserved judgments?
No, I don't. Okay. No, I beg your pardon. No, I do. I acted in September. I think I finished acting on the 4th of September, and I have one judgment that needs to be done there.
You mean this past September?
This past September,
okay.
Yes.
All right. The GCB has written an overall complimentary assessment about you. But they do raise the issue of 2 judgments that you delayed, they say.
Yes. DCJ, would you like me to
Would you, yeah, what do you have to say on that, if anything?
DCJ, there's 2 things. I did a response in which, to that, I believe that was something that did call for a response. If I may just give a little bit of a background for a moment. These were both third-party matters. With the Road Accident Fund having withdrawn the mandate of its panel attorneys, what happened with the third-party trials is you would have a plaintiff with their reports, and they would seek judgment. The matter will then be decided on the papers, which I found initially very difficult to do, because here's a trial and deciding it on the expert reports. But my experience was that counsel that presented those cases, probably acting in the best interests of their clients, I would think, would not necessarily draw attention to matters that were unfavorable. And considering that the funds were public funds, I considered it my responsibility to interrogate those. So I would hear an argument for an hour. There'd be 3 or 4 matters on a day. You'll hear the argument. You've looked at the reports very quickly. And when I started writing judgments, I noticed that there were certain things that hadn't been explained. So in the case of the else matter, which is the first one that the GCB refers to, what happened there was the plaintiff had been doing some part-time hairdressing, and I remember that specifically. The actuary dealt with that, those extra earnings, but when I went through everything on case lines, there was no evidence to support that. The vouchers for the past medical expenses and the income as well was presented in a very unsatisfactory fashion. I sent an email to the plaintiff's counsel asking him to point me to certain to the various folders on case lines where I could find some of the vouchers. I also asked the basis on which the plaintiff was seeking to be compensated for the part-time activity, the hairdressing. And I waited a long time for those. And I also, it took a long time for me to get a response. It took a long time, some 8 months after the hearing, after I'd requested affidavits concerning the plaintiff's pre-morbid income were uploaded onto case lines. That, unfortunately, didn't come to my attention until the 3rd of December. When these things get uploaded onto case lines, you get a notification, but you get inundated with these, and I don't always look at them. So that slipped me by. It came to my attention in December, and I then started writing the judgment, and I found it most tedious to get through all of those vouchers. So that was really the reason that judgment was delayed. It was unfortunate, and I think where I erred was that I should have immediately contacted the judge president, and I should have said to him, I'm confronted with this, what do I do? What I also found, I found myself trying to present the road accident fund, to try and balance what the defendant's defense was with that of the plaintiff. And I must say that that wasn't a wise thing to have done as well. And I confronted a similar challenge with the second judgment that the GCB refers to. There too, I had communicated with the plaintiff's attorneys, and there it was. Here the problem was, the joint minutes were based So what had happened, a set of experts had met and they'd prepared a joint minute, and they had come to they'd agreed on certain facts. During the course of argument, I was not referred to that joint minute. I was referred to a later report, and I think it was an educational psychologist. And while perusing the files and case lines, I came across this joint minute where there were certain concessions by both the parties' experts. And it then troubled me what the effect of those concessions were, and whether the plaintiff could now try and get behind those by calling a new expert. So I waited. There was then, I believe I had a discussion with the judge president, because there was a letter from the plaintiff's attorney, and I informed the judge president I was sitting with this difficulty that I've not had a response. And the judge president recommended that I prepare the judgment even though I hadn't received a response. So that was the reason for the delayed those two judgments that were delayed.
All right.
I tried to explain that in the judgment as well. I do believe I mentioned it, but I believe that people, they needed to know why it took so long for those judgments to come out.
All right. There is another objection. Well, I'm not saying the GCP lodged an objection, but this one is an objection from attorney, a colleague at the sidebar, attorney Mohozi.
Yes,
who
I've seen that.
Alleges that you treated him most deplorably and threatened him.
Yes, I read that. When I read that letter, I was taken aback. I couldn't remember the incident. I'm aware of this litigation. It's been going on for some time. Mr. Mohozi acts for an importer, and SARS had detained those goods, and it became quite an acrimonious, the litigation became quite acrimonious. I recall the incident where, my junior had to jog my memory. There was a request for a postponement. I'd been instructed by SARS to seek a postponement for various reasons, and I can't remember them now. And there was a discussion between myself as the lead counsel, my attorney was close by, so was my junior, and the legal advisor from SARS. And you'll note I asked them to give me what their recollection of that incident was. And both my junior, as well as the legal advisor, in their, the legal advisor says this did not happen. When you approached him about the postponement, he was very rude. You told him there was no need to behave in that matter, and he walked away. That's as far as I can recall. My junior's response is a similar one. And she talks about the attorney being very hostile from the moment we met him while waiting to introduce ourselves to the judge. The attorney was leading a junior counsel from the Johannesburg bar. And my junior states that the hostility continued even when we walked into court. And she recalls me telling that there was no need for him to be rude. And that sparked an argument. I don't remember you screaming or saying, I will bring you down, and making comments about attorneys in the High Court. I have a vague recollection. He's saying to me something about, and I'm going to be very cautious because I have a vague recollection. It was something that suggested that my client was being high-handed, that they detained the goods, and they had put his client out of business. I remember saying to him that there was no basis for him to make those allegations. But Deputy Chief Justice, there was not the tirade that the attorney refers to. And I independently asked my junior and the legal advisor and the attorney, and I referred to the conversation I had with the attorney before I wrote the letter, and he's got no recollection at all. There was something that came to mind was, this incident occurred in 2019, February 2019, if my memory serves me correctly. If the complainant, if I may call him so, if he was as aggrieved as he makes out to be, and if my behavior towards him was as atrocious as he makes out to be, his remedy would have been to immediately report my behavior to the Bar Council or to report my behavior to the Legal Practice Council, and he did neither. So I'm afraid to say this, but it's got absolutely no merit. There's no truth to it. The attorney used to be employed by SARS, and I don't know what the circumstances were under which he left, but I've always gotten the impression, and so have my juniors, the legal advisors at SARS, that he's aggrieved by something, and perhaps acting for that client makes him, agitates him. I don't know.
All right, thank you so much for that explanation, Mr. Hassim. I'm going to hand over to the rest of the commissioners to put questions to you now.
Yes.
Starting with Judge President Mlambo.
Thank you, Deputy Chief Justice.
Thank you, DCJ, and morning to you, DCJ. I realized that I was remiss. I came running, and I didn't come to greet you, so please forgive me. And morning to President, SCA, other commissioners. Morning, Advocate Hassim.
Good morning, JP.
Thank you. Let's start first with your acting stints. The commissioners have a spreadsheet that we've sent to them that accords with our records, which record in Gauteng a total acting period of about 50 weeks. I think both Gauteng and KZN.
That sounds about right, Judge President.
Just before I go deep into these acting stints, you came to this commission in, was it 2013?
Yes, I believe it was, yes, 10 years ago.
2013, and this commission said you're not ready.
Yes, that's my recollection.
And you accepted that, am I correct?
Yes, I did.
You didn't sulk, you continued acting.
Yes, I did. I believe that was my duty.
Yes.
To continue to do so.
Since then to now, you've done a lot more work.
Yes, I have.
Do you believe you've grown? You're now ready?
I do believe I have, Judge President. I've written a lot more judgments. I have had the benefit, and for that I must thank you and the Deputy Judge President for giving me the type of work that's allowed me to develop my writing skills, to develop my analysis skills, and I was quite surprised when I took an inventory of the number of judgments I'd written, and I must say I was surprised myself that I had written about 55 judgments.
Yeah, and most of your contribution to the division has been in the opposed motion, where I believe you've done, I think, 12 weeks in total,
yes,
over the years.
Yes, I think that's about correct.
That's a difficult court, am I correct? And that's a court where judges pick up reserve judgments.
Yes, yes, Judge President, that's what happens. Unfortunately, some of the matters, even there's a varied number of cases where I could give extempore judgments, I would, but I found that I had to reserve very often.
And the norm, when you get onto that role, is if we don't have pro bono assistance from the bar and the senior attorney ranks, your allocation is something of 14 opposed motions for that week.
Yes, that's about correct.
And you
yes.
have no writing time. And when you finish that week, you go on to another work area.
Yes.
Okay. Now, Let me come to those two reserve judgments. I know those were trial judgments.
Yes.
Usually, my experience as JP is that acting judges, and judges for that matter, who struggle to finalize judgments quickly is because they are grappling with the issues, and it's mostly a complex matter, like a special motion or something that cropped up in the opposed motions. These were trial matters.
Yes.
The delay was caused not because you were struggling to write the judgment, but because you were not having access to the right material in the case lines folder to write the judgment.
Yes, that's correct. And because certain material information hadn't been provided to me.
Yeah.
I was, at some stage, I was told, but why don't you just grant default judgment? But that didn't sit very easy with me. We were here dealing with a defendant that refused to participate.
Yes.
There were issues of public funds. So I did take a lot of trouble trying to find it. And yes, there were things on case lines I couldn't locate. And it was sad, and it was a disappointment how particularly those two matters were presented to me.
Well, you go on to an area I wanted to cover about those judgments, because you're correct. There is a view from some ranks that say it's a default judgment. It's like a penalty with no goalkeeper. Just allow them to score it. What's your business in checking whether everything is in order? I noticed that one of those claims was 6 million rand, isn't it?
Yes, I think it was.
Yeah. Now, what's your philosophy about it? Comes unopposed to you, they say they want this, therefore just rubber stamp it.
I have a difficulty doing that, Judge President.
Yes.
I do have a difficulty, especially when the case is presented to you on the expert reports. And the whole idea about compensation being claimed is for the court to assess the reasonableness of that compensation. And I'm not always satisfied that the compensation which is being claimed is reasonable. I've done third-party work myself, and it is not unusual for higher compensation to be claimed, and then for less to be awarded. That's claim as much as you can. So I'm not comfortable making those awards. What I also realized is that the actuarial calculations, the premise that it's based on is not necessarily what the experts agreed upon. And so I started interrogating all of that. So I believe that...
Well, I think that I want you to continue. There's a tussle now between us as courts about whether we can do that regarding settlement agreements. That is, claims that have been settled, and so let's leave it. But
yes,
this was a default judgment matter where they were saying to you, we want this, and you said, no, I need to be satisfied as judge because the judgment will have my name.
Yes, that is correct, JP.
In terms of reserve judgments, you've provided a list of judgments that you've penned, as you say. Some of them were penned when you were in the KZN division. Most of them were penned when you were in Gauteng. And just going through them all, I noted some, I think of 2 that were 7 months late, probably 4 that were 5 months late, but in the norm, all the others were in that range. That is less than 5 months, 3 months, 4 months. Can you explain what was the reason for that?
JP, I've thought about that.
Yes.
And I think what I did is I miscalculated how much time I needed to allow. Firstly, to prepare beforehand, because these were opposed motions. Yes. What tends to happen is you don't allow yourself enough time to prepare before you commence your stint.
Yeah.
You then hear the matters, and I've never left any time after I've finished an acting stint and I plunge back into practice. And what I then found is that with the demands of practice, you can't always get to writing those judgments quickly enough. And I believe that it was, if I had prepared, if I had paced myself and allowed myself a week or two after I had completed my stint, I would then probably have been able to write the judgments a lot quicker. The other thing was you'd start writing a judgment and then you'd get interrupted. And for me, the only way to do it is to literally sit at a table, start to finish. And I was not able to do that.
I see. But, I mean, as you sit here today, should you be appointed, you won't have the challenge of a busy practice next to you.
Yes.
You don't think that problem will continue?
No, JP. No. I don't believe it would, because it's the demands of practice, and when you get back in, that was the reason for the delay. If I'm to be appointed, I would also have a lot more time to prepare matters beforehand, and I believe thorough preparation makes it a lot easier to get the judgment out.
Yes.
So,
but your firm view is that that's not an indication that you can't do the work.
No, absolutely not. Judge President, if I may mention,
Yes.
if you, and I've only attached, I think 5 or 6 of the judgments that I've written, but the judgments that I have written are in this file and they're double-sided.
Yes.
And my judgments are generally not short judgments. I believe that the parties are entitled to have the reasoning. So I do take time. To put that together.
Yes.
But I don't believe when I'm able to sit down and work and not have demands of practice,
yes,
that I will certainly be able to achieve writing judgments within the requisite time. You'll recall there were times that I think we communicated and I indicated to you that I was having some challenges.
Yes.
I tried to keep you abreast of matters as much as I could.
Thank you. My last 2 questions is, I think you've confirmed to this commission that since 2013 you've grown. You've
Yes, I
written
have.
a lot more judgments. You're now more ready than
Yes,
ever.
I certainly am.
And you're a silk. You've led teams. Am I correct?
Yes, I have.
You're one of the few silk women that we've seen in our courts leading legal
Yes.
teams.
Yes, I have.
And you believe all that has equipped you to deal with the rigors of the Gauteng work?
Yes, absolutely. And those acting stints that I've had, I would like to think with a preschool for me, because I learned how to deal with certain matters, and all in all, I didn't have difficulty when I was hearing matters. I could manage a court, and I'd like to think that I managed the court relatively well.
Yes.
I could finish unopposed motions within a quick space of time. So I was able to do that. So that's been a very good training ground for me. The work experience that I've had has also equipped me to deal with matters slightly differently than I would have in 2013.
Yes. Okay. Thank you, DCJ. I've got no further questions.
Thank you, Judge President.
Thank you, JP. Premier Lesufi, are you among us? I'm sorry, I forgot to check on the colleagues on the virtual platform earlier, but I was assured that they have joined in.
It's usually...
Yes, I'm indeed here.
There he is. All right. Do you have any questions for this candidate?
Thank you so much, Deputy Chief Justice, the Federal Commissioner. Good morning, Advocate Hassim.
Good morning. Is it on screen? I
No,
can't-
he's patched in virtually. So
Oh, I see, yes. Thank you.
Just 2 questions, Deputy Chief Justice, if you don't mind. The first one, I just want to ask Advocate Hassim, when we were having that stint in the small claims court.
Yes.
And if someone has to ask you to advise authorities on the functionality and the work of the small claims court, what would you advise so that it can be improved?
Premier, I'm afraid I'm having trouble hearing. The audio is not coming. For me, I'm having trouble hearing it.
Yeah, so am I. It's not just you.
Oh, is it just not me?
But were you able to get the gist of the question?
There was something about the small claims court.
Would you mind? Your line is not particularly clear, Premier. We're struggling to hear you. I don't know what you can do, but can you repeat the question and
Could I assist DCJ, because I think I heard the question. I think the question was, you've done work in the small claims court. What would you share with the Commission as being the challenges you've observed, and what can be done to preserve that system of access to justice?
There's a few things. I think I haven't been in the small claims court now for some time. I think that the help desk, there used to be a help desk there before. And now JP, I'm looking at you because you posed the question. I'm going to try and look at the screen.
Repeating the Premier's
yes,
question.
Yes, so I don't mean to be disrespectful to the Premier. I think there should be more information that's circulated about the small claims court, what can be done, and how easy it is to access a small claims court. I also think there needs to be, there used to be a help desk, I'm not sure if there still is, but I think litigants, or whether in the small claims court or any other court, tend to get intimidated, and maybe there should be a more of a user-friendly kind of atmosphere. I think it's a very good court. I think it allows people to resolve disputes quickly and cheaply, but also it gives access to people that would otherwise not refer their disputes to court. I know that, I'm not sure what the current jurisdiction is, monetary jurisdiction, but that jurisdiction is high enough to be important to people to pursue their claims there. Thank you, Premier.
Thank you so much, Advocate. I hope I sound better, Deputy Chief Justice.
You sound clearer now.
I've changed gadgets. Apologies about that. Deputy Chief Justice, if you don't mind, I just want to go back to the objection by the Mukhumutsi attorneys.
Go ahead.
Especially when the Advocate Hassim indicates that the basis of the objection should not be considered because it was not tabled with other institutions before, meaning that even if there are processes like this one where people are invited to raise objections, Advocate Hassim feels that is not the correct platform to raise this kind of an objection. And I've gone through the objections. Somebody that feels mistreated, disrespected, and Advocate Hassim implies that her memory didn't carry her well to recall, but has relied on the information of those that were working with her at that time. On that basis, I really feel that should have demonstrated willingness to either engage a person that is objecting or at least apologize, because the victims will always remember the pain. The perpetrator will not. And I don't find the explanation to reject this objection convincing. Am I wrong, Advocate Hassim?
Premier, perhaps I wasn't clear. I'm not saying that because he didn't pursue other remedies, that it is not appropriate for him to raise the question with this body. Of course he's entitled to. There's a procedure that's in place, and the public must be encouraged to object to the suitability of a candidate. I think that's important. There's transparency about that. What I meant to say, and perhaps if I wasn't clear, if I may clarify, I would have expected, if there was a real grievance that would have been addressed 4 years ago, because I believe the incident was in 2019. This is 2023. This is 4 years later. I have seen this attorney on several occasions. We've litigated this matter at least on 3 separate occasions. I've seen him in court. He's never approached me. Had he approached me, I would certainly have discussed the matter with him, and if he felt aggrieved, and I would have apologized unreservedly. There is no question, if somebody feels aggrieved and you're responsible for that, one should apologize. One is never too big to apologize, and I've got no reservations about apologizing. I don't recall the incident. It is the words that have been mentioned there are not words that I use. I don't remember ever criticizing an attorney for appearing in the High Court. In fact, I encourage them to do so. I encourage my attorneys to appear in the High Court. I've encouraged attorneys to join the bar, because they were not comfortable appearing otherwise. So I would never discourage an attorney from appearing in the High Court. I do believe it gives great growth to the individual to do so. The words that are mentioned, that I was going to bring him down, it's not something that's characteristic of me. There was no reason for me to be upset with my colleague. I've not had an incident in the past in my professional life of 30 years. To that, one should add my 2 years of articles and my 1 year of practice. So that's almost a little under 33 years, 32 years of practice. I've never had a complaint of this sort, and I've never responded. That's not generally my manner of doing things, that kind of aggression. I had no reason to do so. The attorney was representing the interests of his client. There was a request for a postponement. The judge was ready to hear the matter, and but nothing I would have said to the attorney would have changed his instructions. And we were in court. We were ready to argue the matter. I wish that Mr. Mokgotsi approached me. What I can add, and I was very reluctant to do so, but now that the question has been put to me, I believe that, to be fair to everyone, I should say that there have been letters that have been written by Mr. Mokgotsi, which I've seen, which have been aggressive, very hostile, and they've, I don't want to say they're defamatory, but they're not the type of letters that one would expect coming from an attorney. The papers which he drafts, and if I recall correctly, he drafts the papers. He would, the language is aggressive. It's not the type of language that I certainly am accustomed to in court papers. Had I known that this was something that would need to be explored further, I would have ensured that I had some of those affidavits here so I could read them out to you to understand the personality we're dealing with. I have been told by various sources that the attorney was aggrieved when he left SARS, and anyone who appears for SARS is the target of his ire.
I'm not entirely sure. I'm sorry, Ms. Hassim. I'm not entirely sure that it's proper to go as far as you do in the latter part of your explanation.
Yes, thank you, Deputy Chief Justice. Thank you. Thank you, Premier.
Any further questions?
Thanks so much.
Any further questions for the candidate, Premier?
No, fine. Thank you so much.
Thank you. Thank you very much. President Molemela.
Thank you.
Voice. Should I go ahead? Okay. Thank you, DCJ. Good morning, Advocate Hassim. How are you?
Good morning. I'm very well, thank you.
All right. I noted that your first acting stint was 18 years ago, 2005.
I think it was 2004, but I stand to be corrected. Yes, it was a long, long time ago.
Yes.
I think it was at the bar for 10 years at the time,
Yes.
perhaps 11.
Yes, and since about 2013, you've been having an acting stint almost every year.
Yes,
And you have been exposed to a wide variety of fields of law.
yes, I have.
I was quite encouraged when you, in response to the JP, you mentioned, you know, a very cautious approach that you follow when you are dealing with default judgments.
Yes, I do.
You have obviously, in the various acting stints that you have had, dealt with ex parte applications.
Yes, I recall now in my recent stint, there was one. I can't remember what the facts were. So yes, I've actually, in the past, I brought ex parte applications as well. But have I heard them? I think I have a recollection of only one.
Yes, it is. Under what circumstances is an ex parte application relief granted?
If the giving of notice will defeat the object of the application, I believe that that is the test.
Yes. Can you think of an example?
I suppose, a good example would be where, let's assume you have a suspect, it's about to flee the country that you can't get hold of, or there's access to money. And usually that's the ones that tend to come ex parte.
Yes.
Where there's money in the bank account, if you were to give notice to the respondent, by the time the order is granted, the likelihood is quite strong that the money won't be in the bank account. So that's a typical example, or that's a very quick example I can think of.
Yes. So in circumstances where you were inclined, or where you would feel inclined to grant an ex parte relief, would you grant a final order?
No, I certainly would not.
What kind of order would you grant?
I would do several things. Firstly, I will establish whether any notice, even if it's a telephonic notice, to say to the person, I'm in court, I might I might consider issuing an order, an interim order immediately, allow the party to come back to court on the same day, depending. But I would generally, I would definitely not issue a final order. I would issue an interim order, usually in the form of a Rule 9(I).
Thank you, Ms. Hassim. Thank you, DCJ.
Thank you, President.
Commissioner Marumachai.
Thank you very much, DCJ. Good morning, Advocate Hassim.
Good morning.
I just want to ask you a procedurally sort of inclined question. Assuming that you are sitting on a matter in the High Court and the parties are just preparing their affidavits and so forth, and the full set of affidavits have already been filed, and you find that one or both parties file further affidavits.
Yes.
Perhaps maybe it might be a further affidavit, or it might be a supplementary affidavit of one of the affidavits that are already that have already been filed.
Yes.
One, is that allowed? And if it is, what is the? I'm not sure if I can say a test that one should follow in order to get those affidavits to be admitted, because it seems like in practice there are legal practitioners who believe that they can just slip in those affidavits in. What is the correct procedure to follow when one has to deal with those kind of affidavits? Thank you.
So the first thing that one would determine is whether the affidavit, for example, is an affidavit supplementing a founding affidavit, because the case, of course, has to be made out in the founding affidavit. If that is the case, I would think that you would have to bring an application asking the court for leave to file that affidavit. And in that application for leave, one of the things you'll have to address is why the need for the supplementary affidavit arose, and why it wasn't that evidence was not put in, for example, in the founding affidavit, or if we're dealing with an answering affidavit, why it was not introduced in that affidavit from the outset. The other situation in which one would come across the need to file a supplementary affidavit is where there's new matter introduced, for example, in a replying affidavit. You will then find that the respondent would like to have an opportunity to deal with the new matter. Generally, one would have to seek the leave of the court and make out a case why it is that further evidence should be received.
Thank you very much. DCJ, with your leave, can I ask a substantive question? Or should I? I'm not sure what is the agreement, whether one question or...
How have you been doing it in the last 3 days?
It has varied. On the first day, it was 2 questions. Yesterday, it was like 1 question.
Well, the first 2 days were senior courts. And I thought the agreement was 1 for the...
No, I will leave it there.
And
that's
you
fine.
know that, Prof. Okay.
Thanks, DCJ. Morning, Advocate Hassim.
Good morning.
Let me also join and commend you for what you have done since the last time you were here. 10 years ago, in 2013, when we were here, you clarified us about the plight of women.
Yes.
If I can remind you what you told us, that women start off at the bar with some work, usually unopposed divorces, and if they are lucky enough, they move on to opposed divorces. Their white male counterparts seem to progress to a level where they get more complex work. As women, you reach a certain level, then stagnate, like you hit a glass ceiling.
Yes.
Assist us to understand 10 years later, what's the situation like?
Commissioner, I would like to have told you that great progress has been made in the last 10 years, but I'm afraid I can't say that. There has been some progress. What you do find is junior counsel are brought into, young women are brought into far more complex matters where they're being led. But the progress has been very slow. You would find in the courts now, you would have junior counsel being led by a senior counsel in specialist type of matters, which didn't occur much 10 years ago. But I'm afraid that unless you are fortunate enough to get that kind of exposure, there are still great limitations that women not only advocates, women lawyers face. I hope in another 10 years I can tell you differently.
Thanks, Advocate Hassim. Thank you, DCJ.
Thank you.
Commissioner Matolo Dlepo.
Thank you, Deputy CJ. Good morning, Advocate Hassim.
Good morning.
Mine is not a question, it's just I see that you don't like blowing your own trumpet.
No, I don't.
I'm just highlighting to the Commission how much work you have done for female attorneys. And you are one of the few SCs who really go out there and make sure that female attorneys get recognized. So I want to applaud you for that.
Thank you very much. I appreciate it.
Commissioner Matthias.
Thank you, DCJ. Firstly, I must say the objection that relate to that attorney and the encounters, I think it was considered by the objections committee and it was dismissed for lack of merit, as I understand. The Premier was not part of that. And coming to my question is, the Constitution instruct courts to apply customary law in matters. I mean, it recognizes customary law and instruct courts to apply principles of customary law and develop it on matters that concerns issues of customary law. What are the safeguards that you believe the court should adhere to in applying principles of custom? Can the court apply? Can the court infuse common law principles in a customary law dispute?
I'm not sure that perhaps they can. For me, I would think whether that can be done or not is dependent on whether it falls within the bounds of the Constitution. If it falls within the bounds of the Constitution and what is intended to be imported one way or another, if it doesn't fall within the bounds of the Constitution, then I would believe that that's not permissible.
Commissioner Bernard?
Thank you, DCJ. I had a follow-up on the question of the Premier. May I first do that before I ask my question? I think we did say follow-ups are in order.
Sorry?
DCJ, I asked whether I may first do a follow-up on the question of the Premier before I ask my question.
All right.
Thank you. Advocate, good morning.
Good morning.
You mentioned something about an apology, but then the discussion went in another direction. So I just thought if you could just clarify whether you'd like to offer, even if it is qualified, some sort of an apology to the practitioner involved or not. It's just to give you that opportunity, because I think you were going in that direction and then went in a different direction. Would you like to offer an apology to that practitioner?
Commissioner
Even
Barnes.
if qualified.
Commissioner Bernard, I'm sorry, I missed part of. I just got distracted. I missed part of your comment or question. Are you asking the candidate to apologize for the complaint that was lodged with us?
No, Chief. I don't know the DCJ. What I'm asking you, she did, in her answer to the Premier, it did sound as though she was touching on going into an apology, and they didn't. So I was just giving an opportunity if she wants to offer some sort of apology or.
No, Deputy Chief Justice, I must interject on behalf of this candidate. I'm not here, counsel. But I think it's responsible for us as the Commission. You have no reason to apologize. We asked you an opportunity to give your representations. You've given your representations. We looked thoroughly at the merits of this complaint. This is a usual altercation that happens outside of court. And that's why we rejected it on the merits. So to now say to a candidate, no, please apologize, is putting the candidate in an extremely awkward position. Because she wants to get the job. She's now forced to apologize, but it's a false apology. So that is why I think that we should stick to what we decided at the Objections Committee, which was accepted before we commenced these proceedings. Thank you, DCJ.
Thank you for the intervention, Commissioner Ngaitobi. That is precisely what I would have said, and I'll take it further. You have absolutely no reason to apologize, Ms. Hassim.
Thank you, Deputy Chief
But
Justice.
I think DCG, because Advocate Ngaitobi is on the complaints committee, let me say, we received the report on that complaint and we are satisfied that there is no reason for an apology.
Indeed. Thank you, Commissioner Lucas.
Thank you very much.
Does that take care of your rejoinder, Commissioner Bernard?
DCJ, I'll accept the ruling in that regard. Can I ask a question?
Yes.
Thank you, DCJ. Advocate, if you could instantly change one thing about your judicial temperament, can I improve something, what would it be?
I believe that I have the right judicial temperament. Of course, if there was somebody that would point out to me any shortcomings I have, I certainly would would try and improve that. You might have noted from the, beg your pardon, the comment from the GCB that there were no complaints about my temperament in court. There were no complaints, and if I remember correctly, there might have been a statement that I receive practitioners well in my court.
Thank you, DCJ. Thank you.
Thank you, Commissioner.
Commissioner Minister.
Yeah, thank you, DCJ, and good morning, Judge. Advocate.
Good morning, Mr. Minister.
Yes, my question relates to the SAB, is it South African Board's case, where you found on behalf of SAB for the defendant to put security on a matter. When the common law principle is that nobody but a peregrinus or a foreigner could be called upon under any circumstances to give security for cost.
Yes.
It could be the circumstances or the merits of the matter in this one might have dictated how you found. But my question relates to Section 34 of the Constitution. Don't you think that if we have a common law that develops to the extent that an incaller or a resident of the country must put security before when they litigate against some of the big corporates with big pockets, it might frustrate access to justice for some of the poor litigants in the country?
Yes, thank you, Mr. Minister, for that question. This matter concerned specifically the furnishing of security by a company. I know of, unless in the case of vexatious proceedings, I know of no case where a incaller has been required to provide security. And I certainly, unless there are very exceptional circumstances, would not be inclined to have a natural person required to give security, because you're quite correct, that will close the doors of the court to such a person. In the case of companies, I believe the principle is somewhat different.
Thank you.
Follow-up, DCJ? Thank you. On the question that the minister has just asked, and I think your answer is quite helpful. There is a particular rule in the Uniform Rules of Court where when a person applies to appeal and leave to appeal has been granted, in order for the appeal to be heard, and I'm talking about natural persons now, in order for the appeal to be heard, you have to furnish security. And sometimes, if you cannot agree with the parties to the amount of security that needs to be paid, then the registrar must come in. And there's always a contention under those circumstances. What is your general view in respect of that particular rule?
The security is only insofar as the costs are concerned, as in the case of the company, the case. I haven't studied that rule in any great detail recently, but it might very well be that there is room to approach a court to dispense with the furnishing of security, and I think that would be where the remedy lies. But I must be forthright. I've not looked at that rule for a very long time.
No, you are correct, actually.
Yes,
Thank you very much, DCJ.
Commissioner Shabangu Mdawe.
Thank you, DCJ. DCJ, let me start by declaring that I know Advocate Hassim from Saula as a member, as well as the chairperson of Training and Development Committee. Good morning, Advocate Hassim.
Good morning.
Mine is to commend you on what you have done or you continue doing for young women, legal practitioners. What I want to find out from you, if you are appointed as a judge, will you continue assisting those young women and empower them?
Commissioner, I'd like to say yes, because I certainly would want to continue doing it. I do believe that there might be certain restrictions. Of course, before I undertake any such activities, I would like to confer with the Judge President whether it's permissible. But I certainly would like to continue with the training and development program. Insofar as the WhatsApp groups are concerned, my concern with those groups is that certain questions are posed. Of course, if you're a judge on that group, you might become privy inadvertently to confidential information, or you could become privy to certain difficulties in the case. It might then be that that matter comes before you. I believe it's quite possible that you could be compromised. So insofar as those WhatsApp groups are concerned, I would be concerned if I were to remain on them, as much as it'll really pain me to leave those groups. But I do believe there are lots of people, and I'll be leaving those groups in very capable hands. But apart from that, I would welcome an opportunity to continue with the training. And support, not only training, but support. Women need women lawyers. We've seen it in Saula and in other organizations. Need more than they need networking. They need support in practice, and they also need, for want of a better word, they need a shoulder to lean on sometimes.
Thank you, Advocate. Thank you, DCJ.
Thank you.
Well, I know that a number of judges in Judge President Mlambo's division, including him, are very active in the mentoring of young, aspiring, and particularly women lawyers. So if you are appointed, you'd be in very good company.
I would appreciate the opportunity to continue doing so.
Good morning, Ms. Hassim.
Good morning, Commissioner King.
I must just declare publicly that we've known each other for a very long time. We did pupillage at the same time, although at different bars, and have, since our very junior days, been involved in the bar structures.
Yes, we have.
Now, as you'll be aware, there are 4 vacancies and there are a number of applicants. And one of the aspects which I'd like you to address, because it may distinguish between the applicants, is the extent of your involvement in bar affairs and its structures since your very junior days. There's been emphasis on the great contribution you've made towards junior women, but it's been a broader involvement with that, and I think that it would perhaps do your application an injustice if that were not publicly expanded upon.
I have participated in various structures, you're quite correct. I became involved in the National Bar Examination Board, initially as an examiner and then later as a chief examiner. I joined the board at a time where, if I remember correctly, it was dominated. I'm being too gentle when I say it was dominated. It was a white male board. When I became an examiner, I encouraged black colleagues and women to join the board, and when there was a vacancy, I'd approached colleagues and I'd encouraged them to make themselves available. That's one of those structures that I can immediately think about, that I participated in.
Thank you very much, Deputy Chief Justice, and good morning, Advocate Hassim.
Good morning, JP.
DCJ, my question was going to be around the complaint, but I'm satisfied that with the explanation by the advocate and the report by the complaints committee, and also to say it is not uncommon for us to receive as a JSC complaints just a few days or a week or so before somebody applies for a position that we have to consider.
Yes.
So I just thought I'll make that statement, but also to indicate, Advocate Hassim, on a lighter note, do not discount your KwaZulu-Natal heritage, because your naval code is buried there. And we know about the naval code, Deputy Chief Justice. Thank you very much.
Now, I mentioned, not at all, it was very strange. My parents were staying in Pietermaritzburg, and I was, I think, 2 months old, and we left. And for many years, I was very aggrieved that I didn't know my birthplace. And I recall at some stage where I demanded that my father takes me to Pietermaritzburg so I could see where I was born. And then there's these little other anecdotes that bring on very fond memories.
Well,
thank you.
Thank you, Deputy Chief Justice. Good morning, Advocate Hassim.
Good morning.
Just back to those reserve judgment comments that were made by the GHCV. I noticed that all three of them involved road accident fund, and the questionnaire approach that you took. You alluded to the fact that that was important because you are dealing with the public money.
Yes.
Yes. Now, the question that I want to pose is, given changes that has taken place in the road accident fund, particularly as it involves many panel of attorneys.
Yes.
And the fact that, on the other hand, there has been issues raised around the need to protect public money.
Yes.
Now, the question that I want to pose is as to whether that questionnaire approach did it not take place at the expense of the victims. I'm mindful of the fact that there's been many point of disputes in the last 3 years around changes that are taking place in the road accident fund, the fight with the Auditor General, the dissatisfaction by BLA, I suspect also by the Legal Practice Council. So the question that I want to pose, while it is important that all those factors must be taken into account, particularly the quest to turn around the situation, because at some point road accident fund was in the red. But your questionnaire approach, the question that I want to ask, did it not happen at the expense of the victims of the road accident fund, or the beneficiaries of the intended beneficiaries of the road accident fund? Thank you.
Yes, thank you, Commissioner, for that question. It's always a difficult exercise when you've got to balance these rights. But you'll recall that this was not a case that I delayed just because I didn't get to write the judgment. There were, I believe in that case, what I tried to do was to establish whether the plaintiff was in fact entitled to the compensation. My concern was that that case hadn't been proved. If I had simply ignored that, that would have been prejudicial to the plaintiff as well. If that claim of hers, for example, the one claim for the part-time job as a hairdresser, if I had simply rejected it, that would have been a grave injustice if in fact there was evidence that could support it. I saw that as a shortcoming in the presentation of the case for the plaintiff. Of course, I didn't know that that evidence was not there. In both the cases, there was a degree of shortcoming on the part of the plaintiffs, legal representatives, and I had requested them to provide the information, and the delay was largely caused by the failure to respond to my requests. But you're quite correct. Those types of cases, they need to be dealt with expeditiously because there are injured people that need to be compensated, and some of those injuries we all know are horrific.
Thank you, Advocate. Thank you, Deputy Chief Justice.
Thank you.
Commissioner Lucas.
Thank you very much, Deputy Chief Justice. Good morning again, Judge Hassim.
Yes, thank you.
No, I went through your papers and saw that you have been nominated very early for Eisenhower Fellow, as well as the Philip Fellowship. My question is, how did that programs contribute to your own development?
No,
and how did it also contribute to you being someone that take empowerment of others very seriously?
Sorry, Commissioner.
That is the question.
Yes, thank you. If I may correct you, I was not part of any of these programs you refer to, the fellowships.
No, it's fine.
Thank you so much.
Are there any questions for the candidate from the virtual platform? No.
Nothing, Chief Justice.
All right. Thank you. Well, it does appear that we've reached the end of your interview, Ms. Hassim. I just want to say this. It's not often that senior practitioners and silks, especially the women, few as they are, make themselves available for judicial appointment, which is such a pity. So thank you for applying and good luck.
Thank you, Deputy Chief Justice.
You're
Thank you,
excused.
Commissioners. Thank you for the opportunity.